is Ms. McLeod's case according to what I have.
Okay, all right.
And I don't see her on yet, so can we go to someone else, please?
Position 34, Mr. Young.
Good morning, Mr. Young. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, Mr. Young? Do you swear affirm the testimony you're about to give before this court would be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Mr. McClain, good morning. I understand this is going to be a negotiated plea.
That is correct.
Good morning, Ms. Duncan.
Good morning, Your Honor. Happy holidays.
You also.
The state's offer in this case is 12 months to serve, 36 days credit for time served, 18 days with balance probated, 2 weeks anger management, and a stay away from 6970 Kimberly Mill Road, and no further contact with James Bolden. The state's basis for this recommendation is that on December 10th, 2022, this defendant did get into an altercation and battered James Bolden at the listed location, who was another tenant in the building in which he lived. The verbal dispute turned physical, and as a result of that, these charges are before the court today. This defendant does have previous disorderly conduct and a resisting law enforcement officer conviction from 2012. Nothing further from the state.
Mr. McClain?
Yeah, I think this is totally prepared. He is asking the court to accept his negotiated plea. All I need to do is have him put in one phone number here with contact information. And if you wish, I sign for you with your permission, as we spoke of yesterday. But since you're here in person, if you want to put your very own signature on there on the paper, you may do that as well. That's it, Your Honor.
Okay. Mr. Young, it's my understanding that in case 22 CR 008230E, you wish to plead guilty to simple battery. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
Yes. Mr. Young, if you have a phone number at which probation can reach you, it would be
Hold
good.
on, I haven't finished, Mr. McClain.
I'm sorry.
I will accept the plea as negotiated. I'm going to waive your probation fees while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation, it will go to a non-report. Okay. All right. Good luck to you, Mr. Young.
Thank you, Your Honor. If you have a phone number, anybody can reach you. It's right there. If you have a mailing address, mail drop, and you check your mail at shelter. Yeah. Hey, come on. Right. So you can sit over there and then talk to McClain. Because we gotta appreciate that.
Position 27, Brooks.
What is the announcement on Mr. Brooks, Mr. McClain?
Let's see, that's 27. That is. Oh, he was not available yesterday. Is that correct, or did I speak to you? He was not available. We need to delay on him so I can speak to him in the audience or in the private area rather. Hey, McClain, speak to him now, please. Yes, you do. Come on.
Position number 3, Mr. Burton. There you go.
My understanding, this is going to be a negotiated plea. Is that correct?
Yes, Your Honor, it is.
Good morning, Mr. Burton. I'm Judge Eric Morrow. This is the state all-purpose counter that we're conducting video to help with the spread of the virus. Agree to have your case heard by video?
Good morning.
Good morning, sir. Can you raise your right hand for me? Swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down, Mr. Burton. Good morning, Mr. Walker. Are you there with me? Is anyone from the state with us?
I'm here, Judge. I'm sorry. My internet connection is going in and out. What position are we on?
Position number 3, I don't see anybody on camera to present for the state.
Okay. Give me 1 second.
Good morning, Mr. Abdullah. Is this your case?
What's the announcement, Your Honor?
This is position number 3, Mr. Burton. It's going to be a negotiated plea, is my understanding. We just need someone from
Okay,
the state to present.
yeah, I'll take it. I'm not
Okay,
sure what's
thank
going
you.
on with Mr. Abdullah, but I got it. 1 second.
Where you get the grant from? McLean gave it to him?
Just 1 second. Let me.
I think we're sterile again.
Sometimes we work like everybody's the same, everybody's not the same.
Your Honor, can you hear me?
Okay, I'm here. I'm sorry. So it's going to be 12 months to serve 50 days, credit for time served, 25 days, balance suspended, and a stay away from Georgia Tech. And it's to both counts.
Yes. Counsel. Anything further?
Nothing further.
Okay. Mr. Doe, good morning.
Good morning, Judge.
You can proceed.
Thank you, Judge. Yes, I spoke with my client yesterday and we're prepared to go forward with the plea as negotiated and stipulate to the venue, place and ID for the purpose of the hearing.
Mr. It's my understanding that in case 22 CR 008120Y, you wish to plead guilty to theft by taking and criminal trespass. Is that correct?
Yes, yes.
Are you under the influence of any drugs or alcohol this morning?
No, no,
You've been represented by counsel. Are you satisfied with his representation?
yes,
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
yes,
Has anyone forced or coerced you to plead guilty?
no, no.
I'll accept the plea as negotiated, Mr. Burton. Good luck to you, sir.
Done, Burton, come on. Come on,
Going back to position 27, Brooks.
Okay. And what's the announcement?
Your Honor, that was a fairly simple case, and as I thought, that's going to be a negotiated plea.
Okay. Good morning, Mr. Rooks. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Oh, yes, sir.
Thank you. Can you raise your right hand for me, Mr. Rooks? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, sir. Ms. Duncan?
Yes, Your Honor, the state's offer in this case is 12 months to serve, 22 days, credit for time served, 11 days with the balance suspended. A stay away from 670 Washington Road in East Point, which is in Fulton County. And no further contact with Jacqueline Friedman, that's JACQUELINE. And there is a notation for restitution, if I have 1 second, at what our victim advocate got from this victim. One moment. And while I'm doing that, and this incident took place at that location stated on the record, where this defendant did cause damage to the defendant's vehicle. He does not know her. He wrote on her car with a rock the word bitch and nigger bitch. So the victim in this case does not want any further contact with this defendant at all. She stated that she does not know him. And in this case, we attempted to make contact with her. We were not able to make contact. We would ask that Your Honor sound for the victim. If the victim is not on the Zoom, we are okay and amenable with amending the restitution at this time.
You can sound for Ms. Duncan.
Ms. Jacqueline Friedman, if you're here for the court today, please make yourself known by turning on your camera and announcing yourself.
Doesn't appear so, Ms. Duncan. Anything further?
Nothing further from the states.
Mr. McLean?
Nothing further, Your Honor. He just asked the court to accept the negotiated plea. He will do his best on any requirements, but I believe it is balance suspended. And I'm not sure I heard anything about restitution. So with no restitution, I believe he'll be done.
Okay, Mr. Rooks, it's my understanding that in case 22 CR 008366E, you wish to plead guilty to criminal trespass. Is that correct?
I state for record, I didn't do that to her car. It's his car, her husband's car. And I didn't write that dirty words on there. I put X and O's and sevens. I was drunk.
Okay, so do you wish to plead guilty to the criminal trespass as to what you did do?
No, please, I'm just saying that.
And
Okay,
to clarify for the record, Your Honor, my apologies. At that time, he did admit to the officers that he committed the damage as stated in the record.
okay, and I think that he has said that what he did. So do you wish to plead guilty, Mr. Rooks? Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with his representation?
Sir, yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury? You don't want a jury trial, do you?
No.
Okay. Has anyone forced or coerced you to plead guilty?
Yes, sir.
Okay, I'll accept your plea, Mr. Rooks. Good luck to you, sir.
Thank you. God bless you.
Thank you, Your Honor. Come on, Brooks.
Can I get my record?
Position 4, Bussy.
Can I get my paperwork? My name on it? Okay.
Let's see, who's representing Mr. Bussey?
Wow. Mr. McLeod.
Ms. McLeod? I saw that she was on. Good morning, Ms. McLeod.
Good morning, Your Honor.
What are we doing with Mr. Bussey this morning?
Your Honor, I don't know if the state has an offer on him. I did not receive one. I received on my other client. So can I get a chance to speak with him?
Is this your case, Mr. Abdullah? Good morning.
Good morning, Your Honor. Yes, sir. This is my case. The state is
Okay, go ahead.
The state is recommending 12 months to serve 48 days, credit for time served 24 days, the balance probated, a stay away from the address 80 West Broad Street, and a mental health evaluation.
All right, so Ms. McLeod, can you call courtroom 2 and speak with your client regarding that?
Yes, Your Honor. I already put my phone number in the chat to them.
Okay, thank you.
You're welcome, Your Honor.
Cosby. Position 7, Cosby. Hold on. I gotta call her.
Oh, okay.
My understanding, this is a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Cosby. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir, yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Sir, yes, sir.
Thank you. You can put your hand down, Mr. Cosby. Mr. Abdullah?
Yes, Your Honor. At this time, the state is recommending 12 months to serve, 24 days, credit for time served, 12 days, balance probated with 6 weeks anger management, no further contact with the victim, Alonzo Hernandez, or the witness, Jose Lopez, and a stay away from 890 Cleveland Avenue.
Any objection to the probation terminating when he completes the 6 weeks of anger management?
Here's how you do this, good morning, Lester.
No objection, Your Honor.
Mr. Doaz?
Yes, Your Honor. I spoke with my client yesterday, and we agree with the offer, stipulate to the factual basis, venue, and ID. Since it is balance probated, I would ask the court to waive Mr. Cosby's probation fees.
Okay. Mr. Cosby, it's my understanding that in case 22 CR 008349Y, you wish to plead guilty to battery, is that correct?
Sir, yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Understand, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Crosby. I'm going to waive the fees for you, the probation fees, while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation, meaning the 6 weeks anger management, then the probation is going to terminate. So the sooner you get that done, the sooner you won't be on probation, okay?
Thank you, Your Honor.
All right. Good luck to you, Mr. Cosby.
Thank you.
You're welcome.
Your Honor. Okay, thank you.
Okay. Well, let me ask you this. What
Who's next?
And what are, answers?
Position 26, Mr. Rogers.
Doesn't matter where I go. Thank you. Okay, that's what I was wondering because.
And Mr. Rogers is going to be a negotiator. Correct?
I would go,
Which screen are you on?
yes. So that's why I asked. Okay.
Who's representing Mr. Rogers?
I do, Your Honor. Mr. Rogers is a negotiated plea.
Okay. Good morning, Mr. Rogers. Can you hear me okay?
Yes, I can.
Good morning, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, Mr. Rogers. Thank you. Ms. Duncan?
Yes, Your Honor. In this case, the state is offering 12 months to serve, 32 days, credit for time served, 16 days, with the balance probated, 6 weeks of anger management, no further contact with Patricia Thiam, that's THIAM, and a stay away from 54 Peachtree Street Southwest. The factual basis for this offer, Your Honor, is that on December 12, 2022, officers responded to that location because this defendant was walking down the street swinging a wooden stick at people. And he was hitting people and street signs. He actually hit this victim in this case with that pole. And we have some concerns about the nuclear events. So that's why this offer is what it is, given this defendant's history, Your Honor. Nothing further from me.
Mr. McLean?
Thank you, Your Honor. The defendant does ask the court to accept his negotiated plea. This person is a stranger. He will not encounter them again.
Okay. Mr. Rogers, it's my understanding that in case 22 CR 008251D, you wish to plead guilty to battery. Is that correct? You're on mute. Thank you.
Again.
You wish to plead? Thank you. Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you to plead guilty?
No.
I'll accept your plea, Mr. Rogers. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
All right.
All right, good luck to you, Mr. Rogers.
Thank you, Your Honor.
Who do we have next?
Position 10, Giles.
Good morning, Judge Mary Agramonte. I'm here on his behalf, present on the Zoom
Ah.
call.
Good morning. How are you today?
I'm doing good, Judge. How are you?
I'm doing well, thank you. What are we gonna do with Mr. Giles today?
I need to speak with the state as towards an offer on it.
Can we just do that verbally right now? And then we'll let you speak with your client. Will that be satisfactory?
That's perfect.
Mr. Abdullah, is this your case?
It is, the state is recommending a 12 months, 150 days to serve with credit for time served, 75 days, 20-week family violence prevention, no further contact.
Is it me or is it Mr. Abdullah?
It's Mr. Abdullah. I'm here. Can you hear me?
I can hear you.
I think the judge went out.
Okay.
Did you get the did you get the recommendation?
I did get the recommendation. There's a few things on it that I wanted to possibly speak with you about. Do you think we could do a quick phone call?
Yes, give me one second. Can you all hear me?
I can hear you. Can you all hear me?
I can hear you.
Okay, and did we get the entire offer?
Yes, I heard everything. There are some speak with me about if me and the prosecutor can do a private phone call before I call my client.
Okay, so
Put my number in the chat.
Okay, sounds good. Thank you.
Judge, it's Melissa. I didn't get the whole thing because they went out.
okay, it seems to be, is it everyone's internet? I believe that we're having trouble this morning.
I was having trouble. I called back in. It seemed to be fixed on my end.
Okay,
My internet is in and out as well, Your Honor.
okay, yes.
Mine
On
is
my end as
in
well.
and out a lot.
Okay, so we'll do the best we can this morning. I think that we're all having the same issue. So let's see if we can just get counsel to speak and on this matter, I guess over the phone, and then I assume that counsel will have to speak with Mr. Giles also. Do you already have the number to the jail to call?
I do not. Can I have that? Does anyone know it?
Yes. Can we put the number to the jail in the chat, please?
Did I need to repeat the recommendation for the court staff?
Yes, please.
So that was 12 months to serve, 12 months, 150 days to serve, 75 days credit for time served, 24-week family violence intervention or prevention, no further contact with the victim, a stay away from the incident location, 949 Washington Street, Atlanta, Georgia, and third-party transfer for the children.
Okay. Ms. Grace, did we get that?
Yes, I need the victim's name. He didn't state the victim's name.
Yes, I'm sorry. The victim is Jayla Hampton and minor children.
How you spelling Jayla?
Jaylah, last name Hampton, common spelling.
Okay, thank you.
No problem.
Okay, Francois Norris, can we go to the next person while we're waiting?
Position 11, Hines.
And who's representing on this matter? This is position 11, Mr. Hines. Who's representing?
Curtis Hines.
Are you with me, Mr. Walker?
Four females, but one of them is.
Dawn said something?
That's the mistake.
Oh,
I'm here, Your Honor. You said
Who-
position 11?
No,
Yes, number
I'm
11.
here for Curtis Hines. I think we were waiting for his defense attorney.
Oh, no, I was waiting for, so I know that we're gonna try to get you to speak. So let's just go on with Mr. Hines right now, and you can speak with counsel when you're free as to the previous matter. Do you have a restitution number, Mr. Abdullah? It appears.
No, at this time, it's gonna be a negotiated plea.
Okay.
We weren't able to come up with the restitution, so it'll be negotiated.
Okay. Mr. Hines, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Good morning. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Mr. Abdullah?
At this time, the state is recommending 12 months to serve, 60 days, credit for time served, 30 days, balance probated, no further contact with the victim, Dawson Centoria, that's CYNTORIA, common spelling for Dawson, and a stay away from 2980 Jonesboro Road, Atlanta, Georgia, 30315.
Mr. Doaz?
Yes, Judge. I spoke to my client about the offer and we agreed to everything except the restitution. So we're glad that that was handled. We stipulate to the factual basis, venue, and ID. Because the balance is probated, I would ask for the court to waive Mr. Hines' probation fees and switch him over to non-reporting if we can, since there's no restitution.
Okay, Mr. Hines, it's my understanding that in case 22 CR 008017E, you wish to plead guilty to criminal trespass, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you to plead guilty?
No, sir.
I will accept the plea as negotiated. Mr. Hines, as far as the balance probated, given that there are no fees, no restitution, is there any other requirement for probation, Mr. Abdullah?
No, that balance is suspended. I'm sorry, I was
Okay.
still looking at the restitution.
Okay, very good. So balance suspended. Good luck to you, Mr. Hines.
position 12, Marcus Hines.
Hello?
Okay, this is going to be a non-negotiated plea.
Yes, Your Honor.
All right. Good morning, Mr. Hines. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Given that this is non-negotiated, good morning, Ms. Jackson. Can you give me Mr. Hines's history, please?
Yes, good morning, Your Honor. If the courts will please bear with me.
Okay, yeah, I understand, Ms. Jackson.
All right, the defendant has 7 cycles, and I'm scrolling up here. Prior to that, the defendant was arrested May the 9th, 2013 in Fulton County for a probation violation. The underlying charges were possession of a firearm by a convicted felon. What else is going on?
No, I don't take it because I'm ready to go.
Okay, I do see a conviction, a felony conviction that was in 2005 in Fulton County for entering an automobile with the intent to commit theft and armed robbery. And another charge, aggravated assault.
Yeah.
And let's see, is there any other convictions? There are no other convictions listed in the GCIC, Your Honor. That's the only one.
All right, thank you. Mr. Abdullah?
Yes, Your Honor, the state would like to lay a factual basis for the recommendation. On December 10th, 2022, the defendant came home intoxicated and accused the victim, Nicole Davis, common spelling, who was his girlfriend, that she had another man over. While at the home, the defendant continued to drink and became verbally abusive to Mrs. Davis. The defendant pushed Ms. Davis to the floor and snatched her keys from her hand. When the officers arrived at the scene, the defendant was still intoxicated and had a bottle of Heineken in his hand. The officers were able to recover the keys of Mrs. Davis from the defendant's pocket. At this time, the state is recommending 12 months to serve, 34 days, credit for time served, 17 days with balance probated, alcohol and drug evaluation, grief counseling, and 24-week family violence prevention. No further contact with the victim, Nicole Davis, and a stay away from the incident location, 3440 Boulder Park Drive.
Your Honor, I do not mean to interrupt court, but I did find a federal conviction out of West Virginia. Seemed like it was a possession of a weapon. That conviction was December the 31st, 2018. Nothing in addition, Your Honor.
Thank you. Mr. Doris?
Yes, Your Honor. We are in agreement with the state on every condition except for family violence intervention program. We're asking for an 8-week anger management course instead to help Mr. Hines get back on his feet. All other conditions are fine. We just don't want to set Mr. Hines up for failure. What I didn't hear the state bring up was that according to the warrant, this incident occurred after Mr. Hines returned from his father's funeral. And he had been drinking, and as the other condition stated, alcohol and grief played a large role in the emotional status of Mr. Hines on that day. Mr. Hines says, we saw little violent histories last. I know we had the possession of a weapon in 2018, but the last violent injury we saw was from 2005. Everything else seemed to be drug related, if I heard pretrial correctly. And for these reasons, we don't want to set Mr. Hines up for failure. He understands that what happened that day was unacceptable, but we would ask for anger management along with all of the other conditions recommended by the state instead of family violence intervention to make sure that Mr. Hines is set up for success and can take this year to get his life back on track.
Mr. Abdullah?
Yes, it seems that the state and the defense has the same goal. We're a little concerned with the defendant's past with firearm and drug related offenses. We just want to make sure that he has all the tools he needs moving forward so that we don't start a cycle of violence with his girlfriend or his partner. And therefore we're recommending the 24-week family violence intervention. If it would be better, we can take off the grief counseling, and hopefully he would get all the tools he needs from that 24-week program. But the family violence is non-negotiable on the state's part.
Okay. So I'm going to help him out, Mr. Doaz, I'm going to order 12 weeks of anger management instead of the FEIP. Okay, so if he wants to accept that, that will be, and with all the other conditions of the state.
Yes, Judge, and we'll go forward with that offer.
All right, Mr. Hines, it's my understanding that in case 22 CR 008244Y, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea your plea, Mr. Hines. The sentence is going to be everything recommended by the state, except the FBIP will be 12 weeks of anger management instead of the FBIP. Let's see, I'm going to waive the fees for you while you're on probation and help you get and stay on your feet, but you're going to have to be on probation for the entire 12 months, okay?
Yes, sir.
All right, good luck to you, Mr. Hines.
Going back to position 4, Bussy.
And Ms. McLean,
Yes, Your Honor.
oh, I'm sorry, Ms. McLeod, excuse me, Mr. McLean.
No problem.
Is Ms. McLeod with us? I'm sorry, I don't see her on.
I can have a seat. Let's see. I'm gonna do. Hold on. Position 16, Johnson.
Your Honor, while that's coming up, may I interject one other announcement?
Okay,
Let's see, I believe it is Javion Mitchell. To better prepare our case, we need to ask to reset that a week, and we'll talk with the state. But we need to ask to reset 1 week on Javion Mitchell. I believe that's number, it's like 22.
okay, so we'll reset till next Tuesday, which is what, the 2nd?
Yes, that would be good, Your Honor. Thank you.
Okay. And this is Mr. Johnson, is that right?
Yes, position
And-
16.
Right.
Thank you. And this is going to be a non-negotiated plea?
Yes, Your Honor.
All right, good morning, Mr. Johnson. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you, Mr. Johnson. Let's see, since this is non-negotiated, Ms. Jackson, can I have his history, please?
Yes, Your Honor, just a moment, please.
572 9588.
I apologize, Your Honor, we have more than one in the system, and I just want to make
Okay.
sure that I'm giving you the right information.
Thank you. I appreciate that.
Yes, but I went to family court and they dropped it down to a misdemeanor, so that's one time.
No. What's his name?
Gordon.
Okay, so would it be another court date?
Okay, the defendant's last arrest was November 26, 2022 in Dunwoody, Georgia for obstruction of an officer, misdemeanor, and simple battery. There is no disposition for that arrest.
Wait. Do we have the correct Marcus Johnson?
Okay, all right. I'm sorry, Your Honor, I apologize. Can you go ahead and talk with counsel and let me go back? I apologize. Let me go back.
Mr. Abdullah?
Yes, the state The state would like to lay the facts for the case. The defendant slapped the minor child, KH, in the face with an open hand during a verbal dispute with his mom. Apparently the child wouldn't eat, and so he slapped the child in the face. As far as his arrest, we have a battery, family violence against the child's mother in 2021. Another battery, family violence, that was charged as a felony. This was just an arrest in 2021. He also has a conviction for battery, family violence in 2018, a DUI conviction in 2016, and a possession of marijuana in 2016. He was arrested for aggravated assault in 2020, as well as a firearm possession during the commission of a felony in 2021 as well. At this time, the state is recommending 12 months, 60 days to serve, credit for time served, 14 days, balance probated with 24-week family violence prevention, as well as a stay away from 320 Fairburn Road, Atlanta, Georgia, and no further contact with the victim, with the minor child, KH, or the minor child's mother.
And what's the mother's name?
The mother's name is Dorothy Tapley.
Can you spell
That's-
the last name?
Yes, that's Tapley.
All right, Mr. Doaz.
Yes, Your Honor. We agree with all of the conditions except for the additional 16 days of jail time. Mr. Johnson has, as of today, served 14 days. And so we're asking for an offer that includes serving 28 days and credit for 14 days in order to allow Mr. Johnson to get back on track, get back to work, support his 3 children these 3 children are, none of them are with the alleged victim. He understands he can't have any further contact with the alleged victim or the mother. Mr. Johnson has served these 14 days and he understands all of the conditions, and he wants to use these additional 16 days to get started on this family violence intervention program and all of the other conditions, and hopefully secure his job back while he still can, and just get started on getting everything back on track.
Okay, Your Honor, if you're ready, just let me know. I apologize.
Oh, there's no need to apologize, Ms. Jackson. You're fine. Yes, I'm ready.
The defendant has 9 cycles. The defendant's last arrest was March the 17th, 2020 with the City of Atlanta Police Department for aggravated assault and possession of a firearm or a knife during commission of a felony. I do not see a conviction for that arrest. I'm going to scroll up and see if there are any other convictions for you. I do see a failure to appear that was on January the 22nd, 2018 in Fulton County. The underlying charge is battery, family violence. See a probation violation that was out of Fayette County. That was on 2017. I do see what that conviction was in Fayette County. It was August the 2nd, 2016 for driving while licensed, suspended or revoked. The defendant received a nolo contendere sentence for that charge. And prior to that, I do see a misdemeanor conviction, additional one in Fayette County, 2016 for possession of marijuana less than an ounce and a DUI. And prior to that, I see a misdemeanor conviction. It's in Fulton County, 2018 for battery, family violence. An additional misdemeanor sentence. The defendant received a nolo contendere sentence, 2015 for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Okay, anything further, counsel?
No, Your Honor.
All right, Mr. Johnson, it's my understanding that in case 22 CR 008264J, you wish to plead guilty to simple battery, family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept your guilty plea, Mr. Johnson. The sentence is going to be 12 months to serve, 28 days, credit for time served, 14 days, balance probated, and with the remainder of the state's recommendations in the matter of family violence intervention program, the stay away, the no further contact. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And you're going to have to be on probation for the entire 12 months. All right. Good luck to you, Mr. Johnson.
Thank you, Judge.
You're welcome. Who do we have next?
Go ahead, Duffy. Duffy, go ahead.
Position.
You've got an echo there. Can you hear me?
Position 5 and 6, Mr. Cameron.
And who's representing Mr. Cameron?
Yes.
Let's see, Ms. McLeod, Mr. Kelbaugh. Do we know who's representing Mr. Cameron?
Your Honor, I spoke with
me,
you
Your
on position 5, but I'm now realizing, I understand, but for position 6, I'm realizing it's a conflict, so that might have been an error.
Okay, so I don't have the offers here. Is there going to be any extra jail time recommended?
Yes, the state is recommending for position 5, that's the simple assault family violence and the simple battery family violence. The state is recommending 12 months, 180 days to serve, credit for time served 25 days, balance probated 24-week family violence prevention, no further contact with the victim, Christian White, that's Christian White. Stay away from
I just needed to know if we needed any extra jail time, Mr. Abdullah, because if there's extra jail time, then we can, good morning, Mr. Kelbaugh. How are you?
Good morning, Your Honor. Sorry about that. I had
It's no problem. I don't believe this is your case. I just was trying to find out whose case this was. And maybe we can get you to, or whomever to represent him for next week. Since there's going to be extra jail time, I'm going to reset Mr. Cameron for next Tuesday. We do need an attorney for him, Mr. Kelbaugh. Would you be able to take on his representation?
Yes, Your Honor. Could
Okay.
the state email to me the discovery for, I believe I represent him on position 6. So
Okay.
am I understanding that the offer, I heard the offer was 180 days, I think, to serve. Was that on position 5 or on position 6, or are they?
That was position 5. I
It's
believe.
also 180 days on position 6 as well.
Would that be concurrent?
Yes.
Okay. And would you oppose a NOLO?
Yes, it would need to be a guilty plea.
Okay.
So, Mr. Kelbaugh, do you want to speak with him today, or would you like to reset it?
Could we reset it, please?
Yes, that's fine. We'll reset till next Tuesday. Will that give you enough time?
Yes, Your Honor. And
Is that's for both positions, correct?
Yes.
Okay.
Could the state please email to me the discovery?
Hey, Attorney Kelbaugh, we no longer email discovery. So once you file your entry on the new case, I'll make sure that the discovery is e-filed and you'll be able to access it online.
Okay. On the older case, I have filed an entry on that one and I have not.
Okay. Okay, I'll let our discovery team know that they need to file discovery, and it should be available today.
Okay, thank you.
You're welcome.
Okay, so Mr. Cameron, we'll see you back next week. Okay, sir?
Yes, sir.
All right. I'll see you next week.
Okay, thank you.
Position 18, Jordan.
Mr. Kelbaugh, do you have any other cases on today's calendar?
No, Your Honor.
Okay, I'll see you next week. Have a happy New Year.
Take care, Your Honor. Likewise.
Thank you.
Oh, could I ask Mr. Walker to call, what is it, 22392?
Yes.
22392, unless you're needed for Mr. Jordan. Thanks.
Good morning, Ms. Challenger. How are you today?
I'm doing just fine. How about yourself?
Doing well. What are we gonna do with Mr. Jordan today?
Your Honor, that will be a negotiated plea.
Okay. Good morning, Mr. Jordan. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you, sir. You can put your hand down. Ms. Duncan?
Yes, Your Honor, in this case, the state's offer is 12 months to serve, 56 days, credit for time served, 28 days, with the balance suspended and no further contact with Shanta, that's SHUNTA Ronins, RONNINS, a stay away from 4590 Fulton Industrial Boulevard. The factual basis for this recommendation is that on December 13th, 2021, officers were dispatched to the location in reference to a dispute between the parties. It was indicated that the defendant struck this victim with an open palm in the face and threw her down to the ground. Nothing further from the state.
Ms. Challenger?
Thank you, Your Honor. Your Honor, this is a negotiated plea. I just ask that you do accept the plea as stated by the state. Also, can you confirm, or I just want to confirm with the court that this case is not the charge that's holding him in custody. I believe he has another one, but there's some confusion as to if he bonded out on that case and rearrested or what. So would you be able to provide that to my client?
Mr. Jordan, good morning. Are you with me?
Yes, sir.
No, I'm sorry. I missed Michael Jordan, excuse me. Mr. Tremaine. Can you help Attorney Challenger with that request?
Yes, I would just research.
Okay, hold on, Mr. Tremaine. We got two Mr. Jordans on, okay? So hold on for me, sir. Go ahead, Michael. Did you hear me?
I did.
Okay.
So he is currently holding on a criminal damage to property felony charge. And he's also holding on this simple battery charge. The simple battery for this case, I'm sorry.
Okay, so he's got one felony that after this, he'll just have the felony that he's holding on.
Okay,
Yeah.
Thank you, Your Honor.
Okay, thank you, Mr. Jordan. And I believe your client has his hand up. Do you need to address that before we move forward?
No.
Okay.
Mr. Jordan, I spoke to you about it. I will talk to your mom and also your attorney for the felony charge, okay?
All right.
Okay.
Okay, so Mr. Tremaine Jordan, it's my understanding that in case 21 CR 007534J, you wish to plead guilty to simple battery, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Jordan. Good luck to you, sir.
All right, thank you.
Your Honor, that concludes my business. May I be excused?
Yes, have a good rest of the day and have a happy new year. Be safe.
Thank you. Thank you. Same here.
Thank you. Let's see. Before we move forward, Mr. Abdul, are you there?
Yes, I'm still here.
I
I'm
know
here.
that Attorney Agramonte wanted to speak with you. Have you all had an opportunity to speak yet?
I'm chatting her now. I'm sending her a message. now.
Okay. I just wanted to make sure that you all were doing that. Thank you.
No problem.
Who do we have next?
Position 22, Mr. Mitchell.
I thought that was going to be a recess. Is this the case that was reset?
Yeah, I have that that Mr. Mitchell was going to be reset. Is that not correct?
Correct, 1 week, Your Honor.
Okay, so we'll reset this until next Tuesday. 1-2.
You already had it. You already had it, John.
Wow.
Wow.
All right, so who do we have next?
Mr. Mitchell.
All right, so who do we have next? 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 All right, so who do
Position 24, Pitts.
And Ms. McLeod, this is your case.
Yes, it is, Your Honor.
And what are we gonna do with Mr. Pitts this morning?
We are going to take a plea, Your Honor.
Okay. Good morning, Mr. Pitts. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Can you hear?
Yes, yes, sir.
Okay. Can you raise your right hand for me, Mr. Pitts? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Ms. Duncan?
Yes, Your Honor, the state's offer in this case is 12 months to serve, 36 days. Credit for time served, 18 days with the balance probated, a stay away from 2469 Piedmont Road Northeast, and no further contact with Robin Brown, as well as 10 hours of community service and 6 weeks of anger management. The factual basis of this case, Your Honor, is that on December 10th, 2022, officers were dispatched to the location in reference to the defendant fighting with and battering the victim in this case. It was indicated that the victim received several injuries when officers arrived. Based on being outside of this location and just having a dispute with this person, this defendant does have significant history with 36 cycles and being a convicted felon. That's the reason for the state's recommendation. Nothing further.
Ms. McLeod?
Yes, Your Honor. Those are the terms of the plea, except for one minor point, Your Honor. My client wants to be able to do any MHET at a place of his own choice.
I don't care where he gets it done. Does the state have any objection to him finding his own? As long as he does it, it's fine with the court.
For Pitts, the state is not requesting an MHET. The offer was 12 months to serve, 36 days. Credit for time served, 18 days with the balance probated. A stay away from 2469 Piedmont Road. No further contact with Robin Brown. 10 hours of community service and 6 weeks of anger management.
Okay, I had seen it on the offer that I received by email. That's fine. It's that those are the terms, Your Honor.
Okay, very good.
We understand.
Anything further, Ms. McLeod?
Nothing further, Your Honor.
Mr. Pitts, it's my understanding that in case 22 CR 008234G, you wish to plead guilty to battery. Is that correct?
Yes, ma'am. Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir. I'm not.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I'm satisfied with my counsel.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, ma'am. Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Pitts. I'm going to waive your probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Yes, sir.
All right,
Thank
good
you,
luck to
Your
you,
Honor.
Mr. Pitts.
Yes, and Mr. Pitts, could you ask them to send your contact information to me in chat?
Okay, yes, ma'am.
Thank you.
All right.
Who do we have next?
Going back to position 4, Bussey.
Okay,
That is my case, Your Honor.
and what are we going to do with Mr. Bussey?
It's going to be a plea, Your Honor.
Okay. Good morning again, Mr. Bussey. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. Mr. Abdullah?
Yes, Your Honor, the state is recommending 12 months, 48 days to serve, 24 days credit for time served, balance suspended with the stay away from 80 West Broad Street. Oh, I'm sorry, balance probated with the stay away from 80 West Broad Street and a mental health evaluation.
Ms. McLeod?
Yes, Your Honor. We are asking the court if my client could have the mental health evaluation in a place of his own choice.
Any objection to that, Mr. Abdullah?
Does he know where that mental health evaluation is going to take place, or he doesn't know yet?
He has a place in mind.
Could you let us know?
Oh, well, I guess the first thing I wanted to say is,
Hold on.
okay,
Mr. Buster, you have a right to remain silent. Anything you say can be used against you, okay? So quite often people think that they might say something that will help them and it doesn't. And since I have not taken your plea yet, I'm sure that Ms. McLeod would advise that you remain silent. I guess the only question is, do you know where you want to get your mental health evaluation done?
that wasn't the understanding that I had with her over the phone. I thought this was a negotiation plea is what I thought this was. That's what I thought this was, a non-negotiated plea is what I thought this, what we talked about is what I want to talk about over the
Okay,
telephone.
it sounds like you need to talk to him again, Ms. McLeod.
I do, Your Honor.
Okay, all right. So Mr. Bussey, I'll allow you to talk with Ms. McLeod again so that you two can clarify things, okay?
Yes,
Thank you, Your Honor.
All right, that's not a problem. Who do we have next?
Position 23, Mr. Morris.
That's a not guilty plea.
So it's gonna be an arraignment, 23, okay. Good morning, Mr. Morris. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Absolutely.
Okay, you can put your hand down, Mr. Morris. You've been charged in case 22 CR 004628J with theft by taking. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do, and bond is moot in this situation.
Okay, how do you plead, Mr. Morris? Guilty or not guilty?
100% not guilty.
All right, we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date, okay? Mr. McLean, your client has his hand up. Mr. Morris, I'll allow you to speak with, or Mr. McLean can call you at a later time to answer any questions that you may have, okay?
We're in the same building. Court's going so quickly, I can go visit him upstairs.
All right, so he'll talk to you after court, Mr. Morris. Good luck to you, sir. Who do we have next?
Position 10, Giles.
And this is going to be a negotiated plea, is that right?
That's right.
Okay. Good morning, Mr. Giles. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Giles. Thank you. Mr. Abdullah?
Yes, Your Honor, the state is recommending 12 months, 150 days to serve, credit for time served 75 days, 24-week family violence prevention, no further contact with the victim, Jaylah Hampton, that's Jaylah Hampton. Stay away from 949 Washington Street, Atlanta, Georgia, and third-party transfer for the kids.
Yes, Ms. Aguilante?
Yes, Judge, and I say this was a negotiated plea, but for the record, it was my understanding that the plea would result in his release, and I believe that the offer was 150 days with credit 75. Is that a release on time served plea?
It's my understanding that the jail gives 2 for 1. As such, if he served 75 days, that would add up to 150 days, and he would be released as soon as the jail could process him out.
Okay. Thank you, Judge. And the only other thing I would add, Mr. Giles has been in custody, obviously, for that 75 days, which is not an insignificant time. He has not been able to work. I spoke with the state about possibly allowing him to do, instead of the 24 weekly family violence, to do 12 anger management classes. And this is especially because he actually has full primary custody of his daughter, who's 10 years old, with this, the alleged victim. So he had taken this woman to court years ago, got full custody. And so as being a single dad to this daughter who lives with him and his father, I think that the 24 classes at 3 hours each can really have an effect on his ability to parent and bring money in as a single father. So I would just ask that you consider a 12 weekly class anger management course versus the full 24 week. And this is also because I saw the alleged victim actually filed something into the case. I have not spoken with her myself, but she filed something into the case as public record that she did not want this case to go forward. And I'm just letting Your Honor know that, of course, just to let you know, as far as the appropriateness of the 12 classes versus 24.
Okay, so let me see, since this does not appear to be a negotiated plea, Ms. Jackson, could you get me his history? And then Mr. Abdullah, could you tell me the facts of the simple batteries?
If Ms. Jackson isn't ready, I'll go ahead and give you those facts. The defendant struck his girlfriend. Like the defense attorney said, they do share a child, but she's also 5 months pregnant with his child. He struck her in the face with a closed hand. And it was regarding an argument about another man. And it seems that he has been arrested for cruelty to children and battery family violence in 2015, as well as a disorderly conduct in 2020. That's all for the state at this time.
Thank you. Ms. Jackson, anything further as far as the history goes?
The defendant last arrest was on October the 9th, 2022 in Clayton County for giving false information to an officer. There was no disposition there. I do see where the defendant was arrested January the 9th, 2022 with the city of Atlanta for aggravated assault, but there is no disposition for that arrest. So it could possibly be open, Your Honor. Let me scroll up and see if there are any convictions for you.
If I could interrupt, I'm sorry, Your Honor, I did miss that. He actually has an open aggravated assault strangulation case against the same victim from this year, from 2022. That's that arrest that Ms. Jackson was referring to. And for that reason is why we're requesting a 24-week family violence prevention.
There's also a signed affidavit on that case too.
Yeah, well, Your Honor, as you know, it's very common that the victims recant their statements. It doesn't change the facts of the case. Here we have two violent attacks on the same victim. Regardless of whether or not the victim is willing to move forward with her testimony, the facts remain the same.
I do see a probation violation. It was on February 26, 2017 in DeKalb County. I see a failure to appear. That was January 22nd, 2016 in DeKalb County. The underlying charge is criminal trespassing, shoplifting. Let's see if there's anything else going on. Some additional failure to appear. November 5th, 2015. That was out of Fulton County for battery family violence. I do see a misdemeanor conviction. January 29th, 2016 in DeKalb County for theft by shoplifting, misdemeanor. Okay, I see an additional misdemeanor conviction. January 19th, 2016 in DeKalb County for criminal trespassing. And I see another one. That's the same date, so they probably run all concurrent, Your Honor. It was the same date, January 19th, 2016 in DeKalb County for disorderly conduct.
Okay, thank you, Ms. Jackson. I have enough to make my decision. I think that he would benefit from a family violence intervention program, especially since he has a child on the way and he has another minor in the household. So if he wants to plead guilty,
I don't have a
I'm
child.
gonna,
Let's talk loud.
I don't mean to cut you off, Your Honor,
Keep
but
it masked up on,
Oh.
let's talk loud.
I don't have a child on the way. I actually have a 1-year-old child already here. I don't have a child on the way by her.
okay, well, thank you, Mr. Giles. And with that also being said, I do think that you benefit from Family Violence Intervention Program. I'll waive the fees for him while he's on probation to help him get and stay on his feet, but I will require that he do the Family Violence Intervention Program as a term of the probation. If he wants to accept that, we can move forward. If not, let me know.
I'm sorry, Mr. Giles, you're okay with the 24 weekly classes as part of this plea?
Yes,
Yes, or would you rather have the case reset for trial after January and stay in custody?
I'll take the class.
Okay, all right. Thank you,
Okay.
Judge.
All right, anything further before I take the plea?
Nothing further.
All right, Mr. Giles, it's my understanding that in case 20 CR 004999Y, you wish to plead guilty to simple battery, family violence, and simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your plea, Mr. Giles, and I'll accept the state's recommendation as far as the sentence goes. I'm going to waive the fees for you while you're on probation to help you get and stay on your feet, but you're going to have to be on probation for the entire 12 months. Good luck to you, Mr. Giles.
Yes, sir. Thank you, Your Honor.
You're welcome. Anything further, Ms. Alamante?
Nothing further. May I be excused?
Yes, Happy New Year. Be safe.
All right. You're used to, Judge. Bye-bye.
Thank you.
Miss Agar, oh, she hung up.
Oh, I'm sorry, Miss Grace. Did you need something? Okay, who do we have next?
Position 21, Mr. McKenzie.
And this is going to be a negotiated plea.
Yes, it is, Your Honor.
Good morning, Mr. McKinley. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Thank you, sir. Ms. Duncan?
Yes, Your Honor. In this case, the state is offering 12 months to serve, 328 days, credit for time served 164 days, with the balance suspended and a stay away from the incident locations of Virgil's Gullah Kitchen and Bar, Hattie Marie Texas Barbecue, and Milk and Cookies Exotic Snacks. This defendant, from our research, does appear to have 9 circles, last being in March of 2022 for a criminal trespass and false report. He did intentionally damage property at all of these locations on or around July 16th, 2022, and that's the basis for the state's recommendation.
Okay. Mr. McLean?
And for a point of clarification, did I see 4 accusations with a 4th location? We're taking care of all of it together. Was there one drop?
Let me,
Go ahead, Ms. Duncan. I'm sorry.
I was gonna say, let me check. I had 3, but I can check and see if there's another. What I had was 3.
If there's one open, we'd rather not leave it open, but if it's dropped, it's obviously taken care of.
Correct. One moment. Okay, what I see here is that this defendant does have several, had about 8 counts that went with this initial case.
Okay, yeah, one was the noodle restaurant. I just didn't want to leave it hanging open. This is fine what we're doing.
One moment, let me just check. I do see another one that's open, but the calendar had 3. One moment for me to confer with my supervisor about adding that one to the plea. 1 second.
All right.
And Judge, this is Melissa. We also have 4 counts as well.
Okay, thank you, Ms. Grace.
Yeah, I've got the milk and cookies place and the barbecue and the gullah. So I think the missing one is Noodle Restaurant, Noodle, Noodle Restaurant. All these businesses are in a row, so it's going down the street.
Just give me 1 second for the go ahead and I'll let you know in just a moment. I know Mr. Walker is having some technical difficulties.
And when whoever's assigned to Miss Samuel, when they get a chance to call to 2392, that'd be super. While you're on with that.
Okay, so what I believe I heard from Mr. Walker is that it's fine that we add the 4th location of, you said it's Noodle
Restaurant.
Noodle Restaurant to the conditions of this plea. So the state's offer is 12 months to serve, 328 days, credit for time served, 164 days, with the balance suspended to stay away from the incident locations of Noodle Restaurant, Hattie Retail Barbecue, Virgil's Gullah Kitchen and Bar, and Milk and Cookies Exotic Snacks. Nothing further from the state.
And they all have the same accusation number?
Yes.
Yes.
Okay, all right. And let's see, anything further?
Nothing further, Your Honor.
Nothing further from the state.
Mr. McKinley, it's my understanding that in case 22 CR 008365A, you wish to plead guilty to 4 counts of criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your plea as negotiated, Mr. McKinley. Good luck to you, sir.
All right. Oh, Your Honor, will I be released today?
As soon, if you don't have anything else holding you, as soon as the jail processes you out, you'll be released.
Thank you.
All right. Good luck, sir.
Going back to position 4, Bussey.
Have we straightened everything out, Ms. McLeod?
We have, Your Honor. It's going to be a non-negotiated plea.
Okay, and what's not negotiated? I guess
It's the MHET, Your Honor.
Okay. So who's presenting? Mr. Abdullah?
Yes, Your Honor. Could you give me just a second?
I can, and Ms. Jackson, also, since it's non-negotiated, may I get his history when you have a chance to get that done?
Yes, Your Honor. This is for Mr. Bussey. May I have that position, please?
Yes, position number 4.
Well, Your Honor, I don't mind going through it now while they're.
Okay, thank you.
That way I can go through it right quick. The defendant has 31 cycles. The defendant's last arrest was June the 21st, 2022 in Fulton County for criminal damage to property in the 2nd degree and a P&I and aggravated assault. That case appeared to be still pending. That case number is 22 CP 210027. The defendant does appear to have felony convictions. There was one in 2017 for burglary in the 2nd degree that was out of Henry County. And the defendant received first offender treatment in 2016 for possession of cocaine. And there was one in 2008 for aggravated assault. Nothing in addition, Your Honor.
Okay, thank you. Whenever you're ready, Mr. Abdullah.
Yes, Your Honor, the state could lay a factual basis. On December 4th, 2022, officers responded to a criminal trespass call regarding an irate customer at 80 West Broad Street. The store manager, Ms. Jessica Mercer, asked the defendant to leave the store, but he refused. Officers tried identifying the defendant, but he refused to give any information. However, another officer arrived on the scene and recognized the defendant from several other trespassing cases, was able to identify him. He was issued a trespass warning from this property on April 12, 2022. He continues to return to that location. The defendant does have a 31 cycle arrest record, including 2 open cases for public indecency and criminal damage to property from this year. That's the basis for the state's recommendation of 12 months to serve, 48 days, credit for time served, 24 days, balance probated, with the stay away from 80 West Broad Street and mental health evaluation.
And why are you requesting a mental health evaluation, Mr. Abdullah?
I'm sorry, Yana, I didn't hear you.
Why are you requesting a mental health evaluation?
From the nature of the defendant's charges, like I said, in this particular charge, he was irate inside of the store for no apparent reason, which is why he was asked to leave in the first place. He also has two open cases with similar facts, public indecency and criminal damage to property, again, where he was irate for no apparent reason. And so we just want to make sure that the defendant has the tools he needs to prevent him from us seeing him again.
And what is 80 West Broad Street?
That's the food. That's the food depot. It's a grocery store.
Okay. Thank you. Ms. McLeod?
Yes, Your Honor. My client has been locked up for 20 plus days, Your Honor. And our understanding of this plea also, when it was offered, was that the balance would be suspended. It did not have probation in it. So probation seemed to be a new term that the state is introducing at this point. This is a criminal trespass case, Your Honor. It's not an assault or anything like that. He was just having an argument at the store. We feel that probation after the time that he has spent is excessive, Your Honor, that a time served is sufficient. And also there's no need for mental health evaluation in this particular case. I don't see why the state wants this, considering the nature of the charge.
Does he have a place to live, Ms. McLeod?
He does, Your Honor. He lives with his parents.
Thank you. Anything further, Mr. Abdullah?
Yes, if the defense has a problem with probation, we have no problem. We're not objecting waiving probation fees, or also depending on the outcome of the mental health evaluation, putting him on non-report. But the probation is only in place to make sure that he can get that mental health evaluation. Again, this case, as well as the 2 open cases that he have, seem to stem from him kind of acting irate or acting irregular in public places, again, including the public indecency and a criminal damage. So we just want to make sure we can prevent this cycle so that it doesn't grow into something bigger.
Anything further, Ms. McLeod?
Yes, Your Honor, they're saying a mental health evaluation. Nothing is said about, nothing in this plea recommendation says that he will have to undergo any further treatment or anything like that. So we don't see the point of the mental health evaluation.
Sorry, okay. I didn't hear the defense's argument.
Yes, it just says he should have a mental health evaluation. Nothing in the recommendation says that pending the results of the mental health evaluation, anything is going to happen. So we don't understand why it is a part of the recommendation.
Well, we if he can get a mental health evaluation, then we would hope that he would follow the recommended treatment. I thought that was implied from the mental health evaluation, is that you will follow the recommended treatment of the mental health evaluation.
All right, anything further?
Nothing further, Your Honor.
Mr. Bussey, it's my understanding that in case 22 CR 008121C, you wish to plead guilty to criminal trespass, is that correct?
Yes, yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept your plea, Mr. Bussey. The sentence is going to be 12 months to serve, 48 days, credit for time served, 24 days, and the balance will be suspended. You to stay away from 80 West Broad Street, that food depot. You understand that?
Yes, sir. Yes, sir, I do.
You cannot go back to that food depot, okay?
Yes, sir. Yes, sir, I understand.
All right, good luck to you, Mr. Bussey. I'm not going to, given that he allegedly has a criminal damage and another charge on there, I'm going to let them deal with that at the appropriate time as part of that sentence. But this is just a criminal trespass, and I think that time served is sufficient for this charge. Good luck to you, Mr. Bussey.
Thank you,
Thank
sir.
you, Your Honor. Your Honor, that concludes my business before the court today. May I be excused?
Yes, have a good afternoon, Ms.
Thank you,
McLeod.
Your Honor.
Will I see you this afternoon?
Yes, Your Honor.
Okay, I'll see you then.
Judge Morrow, I have a quick announcement for you.
Okay, thank you.
For position 9 is a loan out to Grady.
Okay,
Also, position 19 and 20, they're the same person. Loan out to Grady as well.
for 19 and 20, okay.
And that's it. We're completed here in courtroom 2, Doug.
All right, thank you. I'll see you this afternoon.
Okay, thank you. Happy holidays to you.
Also,
Good afternoon, good morning, Your Honor.
good morning. Who do we have?
This is position 14 in front of you.
Okay,
Come on.
I have that this is Mr. Murphy's client. I don't see Mr. Murphy on with us. Mr. Jordan,
Yes, sir.
do you know if, can you see if you can contact Mr. Murphy to see if he's going to join us this morning?
Okay, I'll give him a call.
Okay, thank you.
I can just another person.
Okay, thank you.
Position 29, Erica Samuel.
All right, hold on a second. Can they hold my report 60 seconds?
Okay,
And Your Honor, Attorney McLean is on the phone. If you could hold for 1 minute on another case.
okay.
You Zoom.
Position 31, Ms. Wilson.
Or Zoom in.
I don't see the attorney for that case. It's listed as Miles Cohen.
All right, I'll tell
I
them.
don't see that attorney on the Zoom.
It's about Erica. Never mind. Thank you. Bye-bye.
Okay, we'll see if we can raise her attorney also. He does not appear to be on the call either.
Position 28, Ms. Sabri.
That is a, not guilty, I believe.
Okay. Good morning, Mr. Bree. I'm Judge Eric Morrow. This is the state good morning, ma'am. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, Mr. Bree. You've been charged in case 22 CR 004826J with battery. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead, Mr. Bree? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you will get notification of your next hearing date.
Yes, Your Honor.
Thank you. Good
May I
luck to
ask
you.
a question before being dismissed?
You can ask, you have a right to remain silent and anything you
Okay.
say can be used against you. You have solicitors here that are listening to everything you say. So Mr. McLean, if you have any questions, he can answer them for you at a later time, okay?
Okay,
All right, good luck to you, ma'am.
thank you.
Your Honor, on the case in which I needed a minute, I was trying to reach the family, giving it one last try, the family of Erica Samuel. That was also a case in which I was wanting to chat on the phone with somebody with authority from the solicitor's office.
Okay, so you need to speak with Mr. Walker?
Anybody that has authority on that case from the solicitor's office, I just wanted to ask them something.
Okay, Mr. Walker, do you want to ask them that privately, Mr. McLean?
Yeah,
That
sure.
was Mr. Walker.
Okay, so can
We're
at
612-2392, I believe is the extension.
I'm not going to be able to call you, so can you put it in the chat, Mr. McLean?
Okay, let me borrow the deputy's keyboard. We have to borrow something to chat, but that's okay. Let's see, there's a mouse. All right.
And on position 31, what is that your case, Ms. Duncan?
Yes, that is my case, Your Honor.
Is this a time served recommendation or not?
What position 31?
31. Okay. Is that Shadari Wilson?
Yes.
The
Yeah,
offer
we tried to call the private attorney, but didn't get an answer.
The offer
Okay.
is 12 months to serve. So
Okay, so why don't we do this, since he's not here this morning, we'll reset this for next week to 2/1. So maybe we can get in touch with him by that time.
Can I get the attorney's name? There's an entry on the case.
I'm sorry, Mr. Jordan, say it again.
Can I get the attorney's name? There's no entry on the case, so I can give them a
Oh,
call.
it's Miles, Miles, Cohen, Cowan.
Thank you.
Thank you. Any word from Mr. Murphy?
He didn't answer, Judge, so I left a message on his phone.
Okay, who's handling position 14? Ms. Hughley, is that you, Mr.
That's
Borough?
me, Your Honor. I'm here.
And what is the recommendation?
Recommendation, one second. Recommendation for Mrs. Hughley is 12 months to serve. Serve 8 days, credit for time served 4 days, balance probated with a stay away order from 2460 Peachtree Road. No further contact with the victim, Corliss King, Corliss King, and a alcohol and drug evaluation, I believe it is. 1 second.
Okay. So it is a time served recommendation. So I really wish that we could get Mr. Murphy on the line.
Judge, it's Melissa. For the
Yes.
case, position number 9, and I think that was 19 and 20, that's loaned out to Grady. Do you have a reset date for them?
Let's reset it till next Tuesday.
Okay.
Thank you.
That was position number 9, correct?
Yes, 9.
Xavier.
And- Yes. And 19 and 20 also.
I'm sorry, Your Honor, what's occurring for 19 and 20?
It was a loan out to Grady. They're gonna be reset till next week.
Okay,
And whenever you're ready, Mr. McLean, just let the court know.
Thank you, Your Honor. Have we yet noted in the case of Leola Robinson, there's going to be a mental health referral. We can't do anything today in today's court with that case.
And what would you like to do with that?
We should either directly refer it to the competency calendar or reset it for a progress to be made in getting records.
Okay, and tell me that, tell me the name again.
It's Leola Robinson. It's in the 20s or 30s in the position on the calendar. 25.
Okay, so let's reset it for a competency calendar. Ms. Grace, do we know when?
119.
Okay, competency calendar for January 19. And South Annex.
I'm sorry to interrupt, Your Honor. Mr. Walker wanted me to relay a message to Mr. McLean. He's not amenable to your questions. He said that the answer is no. His Zoom is having issues, so he wanted me to let you know that.
Understood. Okay.
Yes, Your Honor.
Are you going to be with me this afternoon at the SCA calendar?
Yes, sir.
Can we bring Ms. Hughley back for that calendar? Because she has a time served offer. I'm trying to get her attorney on the line, but he does not appear to be coming. So I don't want her to have to sit there if they're going to accept that offer.
Yes, sir.
Can we just bring her with whoever you bring for the SCA calendar this afternoon? Would that be?
Yeah, I can make it happen. I can make it happen.
Okay, all right, good, because I don't want her to have to sit there if she doesn't have to. I would, and he doesn't appear to be joining us, so thank you.
You're welcome. At position 29, Ms. Samuel, is she done or?
Yeah, she's done. She is.
Miss Samuel, that's the one. That's the one where we were chatting. I'm ready to ask the court to. I'm ready to ask the court to consider signature bond in that case.
So she needs to be arraigned.
Yes, Your Honor, but it was the no offer was made and it was on the calendar as a mental health case, and I wasn't sure what to make of that.
Oh, okay. Well, if there needs to be a mental health,
I think Your Honor, she can get it on the outside. She was off her meds that day. It was one act of walking down the highway or the street.
Michael.
And
okay, I'm gonna have to hear the whole case in that case if you want to deal with the bond issue. But if she's gonna, if she is going to have, you're requesting a mental health evaluation, is that correct?
no, I noticed somebody had put it down. I had never met her until yesterday. She seems fine. She was just off her meds one day and now she's fine. So I don't think a mental health evaluation is necessary at all. I just need to talk to the state about I don't see any lewdness in the case. It's just one incident of walking down the road and without clothes on. And
Okay, all right. So let me, who's presenting for Ms. Samuel? Position 29.
Your Honor, this is my case. It was assigned to me. However, I was instructed to present no offer in this case. The state,
Okay, so we're gonna do an arraignment and a bond hearing, Ms. Duncan. Are you capable or able to do that?
yes,
Okay, very good. Good morning, Ms. Samuel. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you, Ms. Samuel. You've been charged in case 21 CR 001663Y with one misdemeanor offense. This offense carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead, Ms. Samuel? Guilty or not guilty?
Guilty.
Mr. McLean, it's my understanding, Ms. Samuels, that you were going to plead not guilty today. Is that right?
My understanding as well.
If pleading guilty is gonna get me home sooner, I would like to plead guilty.
I'm gonna ask, we're gonna go into a bond hearing, in the next portion, ma'am.
Okay. So.
So am I gonna have to sit there for a year?
No. But, I would recommend that you plead not guilty, and I'll go on to the bond hearing after you do that.
Okay, not guilty then.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. What is
I
the,
forgot what I called you for.
Ms. Grace, do you need me?
No, Judge, I'm sorry. I was talking to Mr. Jordan.
Okay. Do we have Ms. Samuel's current bond?
what I see, Your Honor, is that she's actually not being held on this charge. She's being held on other additional charges that include a failure to appear, felony criminal damage to property, and disorderly conduct from what I'm seeing in the file. This case was I guess it's a rearrest, but she's currently being held on other charges. I don't see the original bond amount. I believe it was an unsecured judicial release based on what I'm seeing on the jailing screen, but I don't currently have that amount. If you give me a second, I can pull that up.
Did she miss the court date, Ms. Duncan?
Yes, there's an FTA.
From whose court?
One moment, let me go back to it.
Judge Edie.
Thank you.
Okay, so you know what I do, Mr. McLean, is that if she misses a court date with another judge, if you want to get it modified, go back to Judge Edie to seek that modification.
Precisely. Let's send it on.
Okay, all right. All right, Ms. Samuel, good luck to you.
Thank you.
And I think that completes the calendar, the 9 o'clock calendar here. And just so they're gone.
I'm sorry.
Oh, no. I just wanted to make sure Ms. Hughley knows that I'm going to see her this afternoon and we're going to try to raise her attorney by that time, okay?
Okay.
All right,
Judge,
thank you.
I'm holding on position 15 and 31.
I've got position 15 as a reset. And I guess who's representing position 15?
That's me, Your Honor.
And that's reset till next week?
Yes, I need to get a social worker out and speak.
Okay, so that's reset for next Tuesday, 1, 2, and what was the other one, Miss Grace?
Position 31 with the private attorney, Ms. Miles Cowan.
And I have that we have reset that until next week also, 2/1, so that we can try to get in touch with him.
1, 2.
Okay?
Okay.
All right, and so Miss Grace, whenever you're ready, we can go over the calendar.
And I am ready.
Okay.
Position number 1, reset 1/19/23 competency calendar. Position number 2, reset further notice. Position 3 and 4 were pleased. Position 5 and 6, reset Next Tuesday, 1/3/23 SAP, position 7 was a plea. Position 8 reset to the 19th competency calendar. Position 9 reset 1/3 SAP. Position 10, 11, and 12 were pleas. Position 13 reset further notice. Position 14 is going to be reset to the SCA calendar for today. Position 15 reset 1/3 SAP. Position 16 was a plea. Position 17 reset further notice. Position 18 was a plea. Position 19 and 20 reset 1/3 SAP. Position 21 was a plea. Position 22 reset 1/3 SAP. Position 23 reset jail jury. Position 24 was a plea. Position 25 reset 119 competency calendar. Position 26 and 27 were pleas. Position 28 reset jail jury. Position 29 reset jail jury. Position 30 reset further notice. Position 31 reset 1/3 SAP. Position 32 and 33 reset further notice. Position 34 was a plea. Any questions, comments?
No, I'm gonna just drive back to the office and email everything in.
Okay, well, I have also that we have a DV bench warrant calendar today, is that correct?
Yes.
Oh, was there Mr. Travis, I believe on there, Travis?
Travis Walker and Anthony Eaton.
Yes, sir, we have two.
I can represent Mr. Travis Walker today, Your Honor.
Okay, I see Mr. Walker on the line. Do you need to speak with him?
No, Your Honor, people in our office did speak to him and we understand the facts, the situation.
Okay, so can we move forward with Mr. Walker right now?
Yes.
Good morning, Mr. Walker.
Good morning.
Let's see, Ms. Duncan.
Yes, Your Honor, the state was objecting to the DV bench warrant set aside in this case. The defendant FTA'd on November 10th. The case was reset on December 5th and scheduled again on December 13th. This defendant did change their address on December 5th, 2022. However, Your Honor, that is the same address in the bond order that this defendant currently has a stay away from. That is the updated address that this defendant gave the court, but that is the stay away address in the matters involved in this DV bench warrant. So the state will vehemently oppose setting aside this bench warrant, and we will request that the defendant be remanded into custody. This case has been either reset and changed his address after, he changed the address before he was set for the most recent inquiry calendar. So at that time, it should be the current address. So therefore, we believe that this bench warrant should not be set aside.
Mr. McLean?
Your Honor, our understanding was that he did obey staying away from the place. And of course, that messed up his ability to get mail there. He is certainly trying to come to court whenever needed, but I think he misunderstood at the time if he changed the address to that, or there must have been some kind of miscommunication or misunderstanding. He's not trying to duck court, but he did take very seriously the admonition or the order, stay away from that location. And that meant that he wasn't going to get any mail there.
Well, the issue is we heard this case a couple of weeks ago, excuse me, Ms. Duncan, and what I was told was that he changed his address to the stay away address, and that was the address that he changed his address to without going through a modification of the bond order. As such, I don't know what his address is at the present time, and if it is the address where he was supposed to stay away from, then you see what the problem is, Mr. McLean, right?
Yes, my understanding is it is not his address, and that he just needs to give the court a good mailing address.
Okay, so what's the address?
Mr. Walker, can you state your address?
Your Honor, am I able to speak?
Mr. Walker, just want to say you have a right to remain silent. Anything you say can be used against you. That's why we have Mr. McLean here on your behalf. regarding that matter. If you want to speak with him in private, I'm happy to give you that opportunity, but I want to let you know that what you say might not be a benefit to you, especially if it's in violation of a bond situation. Okay, so Mr. McLean.
Your Honor, if it makes sense, Mr. Walker, for you not to give your address out in public, then you need to get that to me and then I'll give it to the court.
No problem.
Can he call and talk to you, Mr. McLean?
Can you do the chat right now, direct chat? He can call me on as soon as one of the inmates is finished. Is there another line here? There's not another line here. He could do it in chat to me.
It is coming.
Do you understand what he's asking, Mr. Walker?
Yes,
Okay, so go ahead and get that done.
I need his number or something so I can reach him. I don't have no number.
Can you do chat on your Zoom?
I think he needs to talk to you,
Okay,
Mr. McLean.
then I will. Is there another phone? No. Get his phone. Okay, we need to get his phone number. And we'll call him.
Can you put your number in the chat, Mr. Walker?
Give me 1 second.
They just wants to concur with the court that it was brought to my attention that this defendant did previously state that he was back at that address. I guess the last time he was before the court, and the address was changed before he was before this court again. And he said that in open court last time. However,
That was my recollection, Ms. Duncan.
correct.
I'm sorry, I simply have been told the opposite, but
And Your Honor, I'm sorry, I've been in and out all morning. As you know, my reception has been terrible, but I actually handled that case and you are correct. And that's why it was reset today. And that was the statement made in open court by the defendant.
Yes, and I gave him the opportunity to rectify that situation, and we'll see what's what, Mr. Walker.
Okay. And just for the record, there has been no motion to modify bond filed by the defense either.
Okay, thank you.
okay, I've got a phone number. I'm gonna be able to get to a phone to call him and find out what's what. Let's see. All right, the deputy's gonna direct me to a phone that's not in use.
Okay. And let's see, do we have Anthony Eaton on the line yet? Doesn't appear so. Okay, we'll be in recess, I guess, until either Mr. Eaton joins us or Mr. McLean rejoins the call.
Oh, I heard you're rocking and rolling.
Yeah.
I never.
Yeah, it's probably.
Yeah. I can run out to my car and use the. Okay. Right. Tell me about yourself.
Okay, yeah, that's what it is. I'm just, you really not a lot of wrong stuff, but yeah, I'm just.
Okay, we know all that. You ready to represent? We have the meeting idea. Does he have the pass? No, I know.
Basically, I got to see.
Room 2, could we get you all to mute? Well, he's coming, no, he's coming back. I just,
Oh, yeah. Sorry, I thought we were on mute, sorry.
okay, no problem.
Okay, that explains a lot, Your Honor. He has private counsel who's trying to get on Zoom, who knows all about this and is about to represent him as soon as he logs on to Zoom. And
Okay,
that totally explains why I was wondering a couple of things. Thank you.
okay, thank you. And is this, Mr. Jerome, is this your client, Mr. Walker?
Yes, it is.
Okay, good morning, sir. I'm Judge Eric Morrow. Mr. Walker was before me a couple of weeks ago, and we reset this until today's date with some concerns that we had. What would you like to tell the court?
You said with some concerns that you had. I'm not sure where we are in the case right now. We filed an entry in discovery, and we're just waiting for discovery on this.
It is my understanding that Mr. Walker has missed court on a number of occasions on November 10th and December 13th with regard to this matter for division judge. When he was on a couple of weeks ago before me, he let me know that he had changed his address. Unfortunately, the address that he gave the court that he changed to was the court that was the address that was on the stay away on the bond order. So we were confused regarding that matter. I reset Mr. Walker's case to give him the opportunity to let me know why this bench warrant should not be set aside, and that's where we are today.
Okay. Well, in reference to the December 13th court date, I was retained before that court date, and I contacted the court, and I was not aware of that court date, and I was retained before the December 13th court date. As far as the November 30th court date, I was not aware that he had missed that court date, but it is my understanding. I apologize. That if he did not receive notice, then that's not a fault of his own. I understand that the address on the stay away order is his address, but I believe, I apologize, Your Honor. Give me 1 second here. I believe that Mr. Walker told me that the victim never stayed at that address. That was his home, and at his bond hearing, they never informed him that his address was going to be the stay away address, because that didn't make any sense, because the victim didn't live there. He lived there. So what I would ask Your Honor is if you could vacate or not issue any warrant. Now he has counsel. I'm going to make sure that I receive all notices moving forward, and there will not be any missed court dates. And also, we could amend the bond conditions if the prosecutor wants to look into it and contact the victim to verify their address, and then allow us an opportunity. And we could file something if you prefer to amend the bond conditions, because from my understanding, that's not the victim's address.
Okay, so basically what you're telling me is that, well, we have a bond order, whether he knows it or doesn't know it, that is in effect, that has a stay away from the address that he informed us that he was living at. So I guess what you're going to have to do is that if he's at that address right now, you're going to have to seek to have the bond modified. Ms. Duncan, you want to chime in?
And if he's currently at that address, as the state has previously stated for the record, we would request that this bench warrant not be set aside. That original August bond order was set by Judge Law, who in my experience has been very clear about what the conditions of a stay away mean. And even if it is the defendant's home, she makes it clear that they have to stay away. She's not in the business of making a victim leave where they are residing. These charges are battery, family violence, cruelty to children in the 3rd degree for 3 counts. So the state would just be asking, since this defendant has missed court on several occasions and has continued to reside at that address after being told not to, that this bench warrant not be set aside and that he be remanded into custody, and that his counsel further make any changes after that. Because at this point, Your Honor, we are seeing a dangerous pattern here, and we want to make sure that we're keeping this victim safe, as well as we're making sure the defendant is accountable for the actions that he's taken as far as what's alleged to have occurred in this case.
Your Honor, there's no dangerous pattern here. There's just ignorance and negligence. That's it. There's no danger. There's no intentional or malicious acts on the part of the defendant.
Okay, so what I'm going to do is that I'm going to, again, since Mr. Jerome, have you filed your notice of appearance?
Yes, I have, Your Honor.
Okay, thank you. Ms. Duncan, I want your victim advocate to contact the alleged victim in this case and to find out what her, if she is living at that address at the current time, and if she's not living there, has she been living there? Mr. Jerome, I'm not going to set aside the bench warrant at this point in time. I'm going to reset this till next Tuesday. Ms. Duncan, if she doesn't live there, I will maintain a modification of that bond order. But I want to hear from the victim before I do, or the alleged victim, before I do anything further. So you understand what the court wants to do, Mr. Jerome, Ms. Duncan? I'm going to reset this until next Tuesday to allow you all to figure out where the alleged victim is residing. And if it's not at that place where Mr. Walker tells me that he is living, then I'll allow him to be there.
And Your Honor, and thank you, Honor, and I received that, and we will attend next Tuesday. But I just wanted to add that Mr. Walker said that if the court wants to check, that address is currently vacant. He doesn't even live there. He said since the last hearing, he's been staying with his mother, and the address that is on the bond order is vacant. He doesn't live there. The victim doesn't live there. No one lives there.
Okay, and so where's the address that he's living at the current time? Have you changed that address with the clerk's office?
Your Honor, we only see the one from December the 5th, as far as the state. And if that's the case, it's the defendant's responsibility, as he's been in front of this court several times, to make sure his address is correct.
Okay, so I'm going to leave everything where it is today. When I come back next Tuesday, I expect that that we will have spoken to the alleged victim, and that Mr. Jerome, that you will have changed his address with the clerk's office to reflect where he currently is. And at that point in time, I'll make my decision about setting aside this warrant. Okay.
Thank you, Your Honor.
All right. I'll see everybody, Mr. Walker, back next Tuesday. All that's completed by that time. All right. You're welcome. Have a good day, Mr. Jerome. You also, Mr. Walker. I see that we have Mr. Eaton on the line regarding the 11 o'clock calendar. Mr. McLean, are you representing Mr. Eaton this morning?
No, Your Honor. I was instructed that he had been informed that he did not qualify for our services and that he should either go pro se or hire an attorney. Is that correct, Mr. Eaton? No.
Mr. Eaton, you have to unmute yourself.
Oh, I'm sorry. Can you hear me?
I can hear you. I can hear you, Mr. Eaton. It's my understanding that you don't qualify for the services of a public defender. Have you hired private counsel to represent you in this matter?
Well, I've actually spoken to paid counseling. I wasn't able to pay her right away, but she said that she can represent me in the very near future. Sharice Challenger.
Okay. So let's see. So you have two options. There is currently a bench warrant out for you, Mr. Eaton, because you missed a court date. So
Yes.
if you would like me to reschedule this for next Tuesday to give you time to hire counsel, I'm happy to do that. If you want to move forward pro se today, I'm happy to allow you to do that. What would you like to do?
Well, sir, there's a very reasonable explanation for that because the address that my court date was sent to. I'm sorry.
Let's proceed pro se, then I have to advise you that you have a right to remain silent. Anything you say can be used against you. We have prosecutors on the line that are listening to everything that you say.
I
You do have
understand
the
the
right.
law.
Okay, you do have the right to
understand.
have. Okay,
And
please
I was,
Mr. Eaton.
I'm sorry.
Please let me finish. Okay,
Okay.
I'm doing this for your benefit, so please don't talk
Yes.
over me.
I
All right.
apologize.
You're fine. You have a right to have counsel present at these proceedings. It's been my understanding that you do not qualify for the assistance of the public defender. I'm giving you the option of either coming back next Tuesday with counsel and addressing this, or if you'd like to proceed pro se today, I'm happy to allow you to do that also. All I know is that you missed a court date, and if you want to explain to me why, I'm happy to hear that also. What would you like to do this morning?
I would like to explain why I missed the court date, sir.
Okay, so first of all, let me speak with the prosecutor to find out what you missed and when you missed it. Ms. Duncan?
Yes, Your Honor. In this case, it appears that this defendant was scheduled, well, he made bond and was scheduled to appear at arraignment in September. However, the defendant failed to appear for arraignment before the defendant was scheduled to appear for arraignment. There was a return to sender in August. Since then, there has been a bond forfeiture ordered on December 20th. There is an updated address on that bond forfeiture indication, and then we're here today. So it looks like he only missed the arraignment. However, the state would be opposed to the bond, the DV bench warrant set aside, and we ask that the defendant be remanded into custody. It's his responsibility to make sure that he has his address correct with the court. We also see that before that, the case had been reset a couple of times, and eventually, since he had a pretrial bond, he was able to get out. So we want to make sure that this defendant is being held accountable for those actions, and we make that request to the court on today.
What is the address that you have listed?
The address that I have listed on the return to sender was it looks like 22 Peachtree Avenue, and the address, the other address that I now have is 772 Woods Drive.
Okay, Mr. Eaton, do you live at 772 Woods Drive at the present time?
Yes, Your Honor.
Okay, so what I normally do is that if you've only missed court one time, I'm going to give you the opportunity to appear the next time. So if the 772 Woods Drive address is correct now, you're going to get notification of your next hearing date at that address. Okay, so I'm going to set this aside one time. So you're using your one side time that this court normally sets aside a bench warrant, but you have to make sure that if you do move again, that you update your address contemporaneous with your moving, and that you attend any hearings, especially since the other notice was returned. Okay, so I'm going to set aside this bench warrant at this point in time. Okay.
Thank you, Your Honor.
All right. Any other questions for me, Mr. Eaton?
No, I actually that was the only thing I was going to say is because the only reason the court date was because it was sent to the address I was supposed to stay away from.
Okay, all right, very good. Thank you, Mr. Eaton. So we'll set this aside this one time.
Thank you, sir.
You're welcome. You have a good day, sir.
All right, thank you.
All right, and I think that completes both the calendars for today. Thank you all. I will see you next week. Have a good New Year if I don't see you all. All right.
Good New Year, Your Honor.
Thank you.
Same to you.
Thank you. Ms. Grace. Ms. Grace, are you with me?
Yes.
All right, so I'll need either from you or Mr. Jordan, the form set aside since Mr. Eaton didn't have counsel, if you don't mind.
Okay,
All right, and I'll get everything signed as soon as you get it to me.
no problem. Thank you.
All right, thank you.
Bye-bye.